All classes are now recorded, so behave yourselves, people. Right? Your middle name is Behave or Misbehave?
Oh, yeah, misspelled.
Depends on which person we're talking to, right? Good morning, everybody on Zoom. Let's start the video here. I'm going to share with you my screen. Loop. Okay, everybody on Zoom, you can see the .loop screen. Is that correct? Okay, perfect. Somebody's shaking their head, so that's good. All right, so you guys, the sign-in sheets going around?
Yes.
You
guys will be super excited. I can't wait for you to see the training. We actually have windows on the one wall. It's bright, it's open, it's wonderful.
It's twice the size, right?
It's not twice the size, but it's definitely bigger. And it's also in the middle of the office, so you don't have to worry about having all the other offices real close by. I think there's a couple offices, but not many, so it'll be nice. I'm going to shut this screen off, or shut this light off rather, so you guys can see the screen up here. Plug this back in because somebody has unplugged it. Let's see if I know what I'm doing. It's gonna pop up there now. Hey, how about that? Good. Me that knows nothing about technology can plug in a cord, so we're good. All right, so this class is about addendums, and it's basically anything. We're going to jump around a lot because we have listing addendums, we have sale addendums. There are different paperwork for different situations, so we're going to bounce around a little bit. It's interactive, so ask questions. Those of you that are on Zoom, you guys can ask questions too. If there's scenarios and different situations that we learn from, so feel free to share a little bit. Keep the stories somewhat to a minimum as much as you can, so that we can get through the class. But certainly, if you have something to share that other people can join and learn from.
Singling me out already.
Well, you just did it to yourself, buddy.
My wife.
He's talking to you.
Right, that's why you guys are in the back of the room. All right, so we're going to get started with some addendums that I guess could be used more frequently at this particular point in time, not necessarily addendums that you will use all the time, but certainly for this market, it's a little crazy right now. And so kind of want to give you an idea of some forms that our attorney has put together for us that you guys can utilize should you find yourselves in specific situations. All right. So this is a notice of contemporaneous offers. So it's to inform you that another buyer that I represent has also written an offer on the property purchase located at blank. So there's not many homes available right now, right? And we're all working with probably the same buyers, maybe showing the same property multiple times to different buyers that we represent, whether you're on a team or just an individual agent. You will run into the fact that you will write an offer for one particular client on a property, and you will have another client that same day or at the same time, even possibly or the next day, also want to write an offer on that same property. Now, the problem with that is you know what the other offer is, you wrote it, but you also have to competently represent both parties equally but neutrally without giving one power over the other offer, basically. So in order to do that, a lot of times I get a call that says, hey, I've got two buyers that are interested. How do I handle this? Well, the first one is easy. You show the house, you write the offer. You don't have to say anything to anybody, right? The first offer that you're writing, they don't need to know anything about it because you've not written another offer. You have somebody that maybe wants to write an offer on a property, but they haven't actually written it yet. So the first offer, you're good to go. You don't have to use this. The next offer that you're going to write, if it's on that same property representing a buyer, you're going to want to present this to them and get their signature on it. And this is giving you written permission that's authorizing you to actually represent both of your buyers on one property. Okay. Now, the person may say to you, hey, don't do this. No. Or you may not be comfortable with it. And in that aspect, you might say, hey, I'm going to get another agent in my office. I'm going to work out something internally, referral wise with them. I'm going to go ahead and put you on notice that I'm not going to represent you in this transaction because I've already written an offer on a property, on this property, and I have to represent that buyer to the best of my ability. And if that's your comfort level, great. If it's your client's comfort level, great. It just depends. But give them this notice. You're going to put your name here, your contact info, and then you're going to have your buyer sign it. And again, that's just that second, third, fourth buyer, not the first one. Okay. So has this happened to anybody recently in this market? Yep. Achilles. Okay. I think, I don't know, something jumped on here or chat. I don't know. Okay, well, I don't see it now. But anyway, any questions about that? So again, not the first person, but definitely the second or after.
I guess I'm just curious why the first buyer wouldn't have to be notified, because if you get into negotiations, you're.
Well, the first buyer, if I write the first offer on the property, I know what the first offer is, and I've most likely written it and submitted it, right? So I don't have an opportunity to say to that person, hey, I am now writing an offer for somebody else. You weren't in this situation in the first place. So
I think it'd be
though,
more if the agent said, like, what if those were the two offers on the table at the end for some reason? Then you're potentially, you know what I'm saying, how sometimes an agent will.
Yeah, but the thing is again, the first one that you wrote, you weren't representing two different parties. You were only representing one. So that doesn't change until you write that offer for the second person. So that second person. Now, could you absolutely go back in your situation where you're saying, hey, the last two on the table are mine and I'm representing? Would it be a good idea to do that? Absolutely, because you're going to get a very angry person that would find out after the fact. But the law says the first person, you write that offer, you submit it, you're good. It's that second one that you have to let them know that you've already written an offer. But I think that's really a best practice. That yes, you're absolutely right. And sometimes, one of the buyers might pull their offer. One of the, the first buyer might actually say, I don't want you to represent me. I want somebody else to represent me. So you just don't know what the situation would happen there. But always a good idea to disclose. But this is something that you will use in your career. Believe it or not, you will write an offer on the same property for two different buyers. And again, if you're on a team, depending upon how that team is set up, a member of your team that is a dual agent may have already written an offer on that property. You don't know. It depends on how your team is set up. So
I think that's about to happen to me over the next 2 days, because that two buyers tell me they want to see the same property. So
yep, it's bound to happen with a limited inventory that we have.
If the first person gets a counteroffer, then you have to disclose no matter what, right?
Yeah, if you're getting a counter offer, now you've changed things where you have to disclose, hey, I represent another buyer on this. But at the same time, usually you're going to get one counter offer, right? So I mean, if you write an offer with me and then I end up writing an offer next with somebody different, his offer is not going to get countered most likely. Yours, they're only going to counter one offer. So if I'm coming back to you, I don't really have to disclose that I made an offer for him too, because I'm now negotiating one offer, not the other one. So, but it would depend on which offer you're getting back. If it's the second offer, well, then you've probably already disclosed that you're in this situation. So it just depends. That's the thing. Every situation can be different. These addendums are only as good as the situation that you're specifically in. They're not 100% foolproof. All right, there was a chat. Okay. You just notify the second buyer of multiple offers. Do you need to notify the first buyer you're in multiple offers? Okay, well, it depends. So we're not necessarily talking about multiple offers when you are representing, like this would be as if you're a seller, Talina. So if I just notify the second buyer of multiple offers, do I need to notify the first buyer that you're in multiple offers? It depends on whether or not you're going to actually be in multiple offers. The seller would be the one that would indicate whether or not you were in multiple offers, not the buyer's agent. I understand what you're saying in this particular situation. You as the buyer's agent understand that you're in multiple offers, but unfortunately, you don't have a choice, but you have to tell that second buyer that you represent a first buyer. So you're not necessarily disclosing that you're in multiple offers. That's not the intent of what you're doing here. You're disclosing the agency relationship that you have with that particular client The multiple offer, unfortunately, yeah, that comes subsequent, but that's not the goal. So they're going to, it's going to be inferred. There's no question about it. But no, you wouldn't go back to the other person, because then how are you competently representing the second buyer, right? I mean, the first buyer might say, I don't want you to give permit, I'm not going to give you permission to say that there's another offer on the table, or the seller may not, because the first buyer might pull their offer. So you're kind of in a sticky situation there. You're inferring it, but you wouldn't say it. You would just say, I have written an offer for another client on this property. That you can say, that's the intent of this document, not to disclose multiple offers. Okay. Thought I could say that. Any other questions about that? Okay. Scott, would you be so kind as to close that door? Just like I said, I can talk kind of loud, and I really hate to have everybody that doesn't want to be a part of the class have to listen to it.
I've written another.
All right. So this is a newer document that we've had at our disposal for a couple months now. This is kind of a weird name, replacement property addendum. It is in miscellaneous documents. It also might be in the sales folder. So this document is used when you are representing a seller that says to you, I do not want to sell my house until I'm willing to sell my house, put it up for sale, but I need the offer that we're going to accept contingent upon me finding suitable housing or replacement property, whatever that would be, whether it's a condo, single family, multifamily, whatever it is. If I can't find something to close on, I am not closing on my house currently, because the only reason I'm selling it is because I can get a good price for it right now, and I want to see what else is out there available. And if I find something great, if I don't, I'm hunkering down and I'm staying here, right? So what happens is this document, as the listing agent, you're going to then, when you receive an offer from XYZ company, you're going to pull this up out of Dotloop, and you're going to sit down with your seller, and you are going to say to the seller, how do you want to proceed? Okay, do you want to, we're going to check box 1, we're going to the execution of a purchase agreement or contract for the replacement property, which has been signed and accepted and is not contingent on the purchase of any other property. So you have that option 1, which I don't necessarily suggest to you unless possibly you have a cash transaction. Number 2 would be the box that I think is most appropriately checked, and that is the closing of the replacement property as defined in the real estate purchase agreement for the replacement property. Now, not all buyers can do that. I know this seems like some legalese here, but understand that typically when a seller lists their property for sale and is wanting to purchase another property, they most likely cannot afford to close on the new house before they close on the old one, right? That's just most of our buyers and sellers out there, okay? So in that instance, unfortunately, you have to check box 1, because you're not going to be able to close on the replacement property without them closing on their current home. Now, the explanation that you have to give to your client is to say, listen, I'm here to protect you, and I understand what you're saying. However, the moment that we sign a new purchase agreement for your property that you're going to be buying, this replacement property, that is when this contingency expires. That is when your contingency is no longer valid. So you are now moving forward with the sale of your current house no matter what. If the new deal falls through, you're still moving. You're out. Okay. So do you have a place to go? And if they say, nope, I don't want that to happen, well, then maybe this is not the right document that you need to use. Maybe you need to put it in the purchase agreement that the seller is not selling the property unless they are able to get a clear close on their new property. So we might have to modify some things in this document or the list or the purchase agreement. Not every situation is very specific, so they differ. But the intent of this replacement property is to put the buyer that is buying your seller's home on notice to say, hey, I'm not selling my house unless I find where I'm going, right? So let's say, for example, you put in here, the seller has a 30-day contingency. So they're going to search for a home for 30 days. And if they do not fully execute a purchase agreement on a new home, or they don't close on the property of a new home, the contract is null and void and dead on their current home. Now, you will have done a lot of work on a listing and secured a buyer, possibly gone through inspections, appraisals, everything, only for the seller not to sell the house, but that's their right. And as long as you've used this document and put that buyer on notice that their contract is not set in stone, it can be null and void after this time period, you've done your job. Okay. I will tell you that we recently had a transaction with the Achilles, which we all learned a situation in this particular instance. This form probably wouldn't have helped in the situation that we were in. It was a very specific situation where had we used this form, just an FYI, we would have probably checked the first box, the execution of the purchase agreement, which would have made it so that these people were moving anyway. And that wasn't their intent. So in our specific case with working with them, we had a seller that said, listen, I'm not selling my house unless I am knowing where I'm moving and I am closing on that particular property. So in their situation, that might not have worked. We would have had to have probably used a combination of this and probably put something like clear to close on the new house or something like that. We would have had to modify something. So it's not going to work for every single situation that you're going to get yourself into, but it is meant to protect your clients. Does that make sense? Okay. You will see this because right now, I mean, I've seen many people that say, well, I'm going to stick my hand up and just put my house up for sale. Let's see what I can get out of it. I don't know if I'm going to sell it or not, but if I can get 300,000 out of it, I might go ahead and sell it, but I got to know where I'm going. Okay. Most of our sellers these days, though, that's not the situation. They're pretty much going to say, hey, if I'm going to sell my house, I'll move somewhere else, even if I move in with family or relatives. But make sure you're having that conversation with them. Okay. Any questions?
What's the typical days, 30 days or 60 days?
Unfortunately, real estate is very gray. There's no black and white answer to give you to say 30 days would be a standard. I mean, if it's a property that's very popular, you might put in there, 15 days because you don't want to drag it out to where a seller has 30 days to look for something. You're showing it for 30 days or you accepted an offer and you're giving the seller 30 days. But maybe what the seller is looking for is a popular property. Maybe they're looking for an everyday 2-story in any township located in Stark County. I mean, that's not most buyers, but hey, maybe that's what it is. And so you're like, hey, I'm only going to give you 15 days because we're going to find what you're looking for, hopefully relatively quick. Now, if you've got a buyer that says, I want a ranch style condo under $200,000 in Stark County, you better put like 90 days in there because you're going to keep looking for it for a while. But I would say to be safe, have the conversation with your seller. How long do they want to be in this contract with their home on the market? Because you've got a lot of things to think about. Are you going to put their home contingent, pending, under contract, allow showings, and they have to deal with showings for the next 30 days? Are you going to put it under contract, not allow showings? And so then you've got that taken care of, that they don't have to worry about showings. It really just depends on the seller.
So is it either way where you do something like possession time on a normal contract? Work it that way as well.
Extending possession.
Instead of the
Okay, well, what happens if you extend possession, but yet the seller still doesn't find something and now they have to be out of their house? They're gonna be real mad at you for selling a house that they didn't want to sell unless they found something, and now they have to be out of their house and they're homeless.
I think you have that conversation sometimes, like you said, most times they have someplace to go.
Most times they do, but just make sure that that's the case. Like I said, we had a situation, like I said, Achilles, they had a client that just said, listen, we're not selling. So, that puts everybody in a unique situation because it's like, okay, well, now we've done all this hard work and you're not going to sell your house, right? I mean, it stinks. So in that particular situation, nothing that we could have done for possession would have been the right answer because they're very strict. I'm not selling my house unless I have a place to go. There are other sellers like that. They're not a unique situation. So, yeah. Okay. So basically, this replacement property addendum is going to be used in those unique situations where you have a seller who says, I'm not selling my house, or I'm selling my house, but I need X amount of days to find something. And if I don't find it, I'm not selling.
And once, even there's no way to reverse. So because you have to sell your house before you can close on the next house. So once the paperwork gets signed on the sale of your house, that's what I'm saying.
On the listing side of it, no, that's if you bring this replacement property addendum up during signing the contract on your listing, the seller that says I'm not selling my house until I find something, then no, that this document protects them from that situation.
Even if they sign to sell.
Even if they sign to
then
sell.
it fell through on their buy side.
Right, because it's going to say here that the offer is contingent for blank amount of days, which begins immediately. If the seller does not identify and purchase a replacement property within the period in this real estate purchase agreement shall be considered null and void, and all monies and trusts returned to the buyer without further liability. Well,
Return to the buyer,
yeah, because the buyer is the one,
the buyer of their.
Right, the
house.
buyer,
Gotcha,
right.
okay.
so the buyer's putting their earnest money down and they're doing all that stuff. Why wouldn't you give their money back if you're not, if I as the seller say, hey, I'm not selling my house, why wouldn't I allow that buyer to have their money back?
This could actually reverse it if everybody had already signed.
No, this needs to be signed at the time that you're signing the offer. When you're meeting with your seller and so Howard Hanna brings us an offer on a Keller Williams Legacy Group listing, right? I'm sitting down with my seller. Howard Hanna did not bring this document to me, but I know I've had this conversation with my seller before. My seller said, I'm not moving unless I can find something. I put in the MLS contingent upon seller finding something of their choice, whatever. I'm going to bring this up and I'm going to pull it out of dot loop and I'm going to say, Mr. or Mrs. Seller or whatever sellers, you need to sign this because this is your understanding, our understanding, and putting the buyer on notices. You are not selling this house unless you find something. Your contract on your current house is null and void in the event that you can't find what you're looking for. Is that correct? Yes, that's correct. Let's go ahead and sign this. Now I'm going to send that offer back over to Howard Hanna along with this document so that I'm putting that buyer on notice. And if they don't sign it, that's when you have a problem because you don't have an offer or you don't have a contract. You have an offer, but you don't have a meeting of the minds. You don't have a contract. Because if a buyer's not willing to sign this, then unfortunately the seller is not going to accept their offer. Go ahead.
If I understood correctly, if the seller gets a house, they go under contract, and that's when.
So that's the dangerous part about this. Like I said, you know, for the situation that you have a seller that says, absolutely not, I am not selling my house 100%. This is maybe not going to work for you because when they sign this purchase agreement on their next home, that has now removed this contingency, right? They've signed it, they've executed it. But what happens if the appraisal comes in short or the seller doesn't want to do repairs or the financing falls through, for goodness sakes, whatever, you know. That's why really the best use of this is the closing of the replacement property. But some buyers and sellers can't do that. Some sellers say, listen, I cannot buy without selling my current house. I have to sell this house for I need a down payment for the new one. Well, in that case, you're not going to get this. That's why I would say, you know, I don't ever want you writing addendums. Like, we're not attorneys and you can get yourself in trouble for this, okay? You can practice law without a license. You can get your real estate license revoked. There's a lot of things that can happen if you try and play attorney. But in protecting your clients, you may have to change a little bit of the wording in this or write it on the purchase agreement that specifically states that the seller is not closing on their current property until they have a clear to close on their new property. Once they have that clear to close language from the lender, then most likely they're going to be comfortable closing on the old one so they can close on the new one. But that means everything is done and moved forward. That makes sense? Okay. So any other questions about the replacement property? Like I said, unique situations, but it's happening in this market. That's why I want to go over this. Okay. All right. So let's move on to do the buyer's occupancy prior to title transfer. I first want to tell you that this form came from necessity. I never recommend that you use it ever. You should never be giving a person that doesn't own a home occupancy or access to it, even if they're storing their stuff in the garage. You shouldn't do it. Okay. I know inevitably you're going to call and we're going to go through these situations. And of course, we're going to work these things out because that's what we do as real estate professionals. But I'm telling you up front, the answer is always going to be, don't ever let a buyer move things into your seller's home, even in the garage, or give them access to the property to fix things or do anything until title transfer happens. It can become an absolute mess. Now, there are times where it is absolutely, it happens, it's necessary, and things work out for the best and it's just fine. But I can also tell you a lot of horror stories where it doesn't work out more than it does work out, okay? But in the event that that is something that your seller decides they're going to do because the house is vacant and the buyer messed up possession on their current house, or they have to be out, or whatever the case is, and they have to get in, and the seller says, I'm not there, I don't care, let them have it. then you're gonna wanna use this addendum, which is the buyer's occupancy prior to title transfer. So this form is going to say what the seller's and buyer's names are, when you've dated the purchase agreement, and what the property address is. Now, the stipulations to this are very clear. And again, this was written by our attorney, so you want to make sure that you're not crossing things out on this or modifying this particular document. So it says that the buyer has requested and seller has agreed, in bold letters, agreed to grant buyer possession and occupancy of the property before title transfers to buyer. So the seller knows right up front, you're giving possession of your home to somebody that doesn't own it, right? Number two, the seller shall provide a buyer with possession on the property of whatever day it is. So today, tomorrow, whatever date it is. Possession. So the seller's obligation to provide possession pursuant to the listing agreement. This document clarifies when they're getting possession as opposed to what the possession date was on the purchase agreement, right? So you had a date on the purchase agreement originally, this supersedes that. Okay. The seller and buyer are hereby advised to enter into a detailed written lease, which you will not write as the agent. You should not ever provide a lease. I don't care if you go online and pull it off the internet or go to Office Depot and get it and give it to your client. That's illegal. You cannot give a client a document for a lease because you are not a property manager and you also are not writing, you're not a party to the lease. Okay, so don't ever provide that. But it is putting them on notice that they should have a written lease between the buyer and the seller. They should do it, not you. Okay. And it basically says if it's longer than 7 calendar days, which most times it is longer than 7 calendar days. Okay. The document does go on to say that there are, that the buyer should get renter's insurance on the property. If there's a deposit, who's going to hold it, who's going to convey it, all those things, how much it is per day. These are all things that you're going to push this paper through, but you're not going to be giving advice to say, yes, I think you should write these lease terms up between the buyer and seller, or here's a standard form that I typically use on my rental properties or anything of the sort. Really, you're going to fill in the blanks. You're going to advise your client on that this is against what we should recommend. And you're going to hope that the buyer gets the insurance. You're going to hope that there is a lease put in place, but you're not going to have anything to do with any of that. Okay. But this is meant to protect your client. So let's say, for example, it's 3 days possession. Okay. We write contracts all the time that give a seller up to 30 days possession. You should be using the next form that we're going to go through, not this particular one, but the next one that we're going to go through. Anytime you're in these situations, the form is available to you, use them. Okay. Any questions about this particular form? Okay. All right, so the next one, like I said, these are things that we do every single day, which is seller occupancy after title transfer. Now, mind you, we are about the only part of the country that does this. There are not many parts of the country that allow somebody to live in a house that they don't own any longer, okay? It's common practice. We used to let people in their homes for up to 30 days completely rent-free, and it wasn't a big deal. Now, more and more, it's becoming a huge problem because a furnace breaks, a hot water tank breaks, the roof leaks, there's a fire, somebody drives through the garage door. There's all kinds of things that happen that you wouldn't think that would happen. Somebody's dog urinates on the carpet, whatever. There's lots of things that can happen when you're living in a house, as we all know. So even if you're doing it for 1 day or 2 days, you actually should be using this form to provide to your client in order if the seller is retaining possession of the residence after closing. For 1 day, 30 days, doesn't matter. Use this form, okay? It's not widely used, and some agents may question you on the use of it. They may say, my client's not gonna sign this. Well, educate your seller, and if your seller says, hey, this needs to be signed along with the offer. You wouldn't bring this up after the contract is accepted. You could, but the chances of a buyer signing this are probably not gonna happen. So that's why I'm bringing these to your attention is when you're on the list side of it and you're having that discussion with your seller, yes, we're going to allow the seller to be in the home for 30 days and I'm representing the seller, you can bring this form. If you're representing the buyer, you can also bring this form attention to whoever the listing agent is and submit it with the offer, okay? So pretty straightforward. It's going to say what the seller's name is, the buyer's name, the date that you entered into, and then it's going to have the specific terms again. the seller has requested and the buyer has agreed to permit seller to retain possession and occupancy. So you've got that. The seller shall provide possession of the property on or before whatever date that is that you've agreed to in the purchase agreement. If the possession is more than 60 days after title transfer, buyer shall notify buyer's lender in writing before executing this addendum. The reason for that is because a lot of times the lender's documents say that the buyer must occupy the home within the first 30 days or 45 days of closing. A lot of times it happens on VA and FHA, not so much conventional, but it can, especially because the intent is you're not buying it for an investment to rent it, you're buying it to live in it. So your homeowner's insurance takes place from the date that you close on it, and the lender's policy takes place, the owner's policy, as well as your mortgage payments. So the seller shall pay rent if they're going to pay rent. You could put 0 in there. Our purchase agreement also has a spot in there that, if somebody's going to pay rent, they can do that. And then the seller shall retain sole and exclusive liability or responsibility for the property, which is important because if something happens to that property, the seller is going to be responsible for it. Our purchase agreement does not convey that a seller is responsible for those types of situations. It basically, the buyer is now responsible. It's their house, they own it. The seller becomes a tenant in their own home. Okay. So using this can protect your buyers as well. Seller shall maintain utilities. I can't believe that I actually had one lady, she was so upset because we negotiated the possession of it and it was my seller. And she said, I would have never agreed to pay rent if I knew that I had to pay my own utilities while I was here for the next 30 days. And I was like, are you kidding me? Who doesn't rent a property and pay their own utilities? If you've ever rented, landlord does not pay your utilities. It was just mind boggling that was, so it's amazing what people think. So make sure, this form really helps you go over things with your clients so that we're not forgetting to bring something up and that they're covered. Seller's occupancy after title transfer shall be governed by Ohio Revised Code with the landlord tenants. And that's important because just because a new buyer owns a property doesn't mean they can go change the locks, doesn't mean they can go in whenever they want. Landlord tenant laws apply, which means the tenant has the right to occupy the property, usually, free of any issues that basically they can live in it just like you can any other property, whether you own it or you're renting it, free of any problems that the landlord is trying to cause you or neighbors or anybody else. Okay. And the parties expressly understand and agree to consult with their respective legal counsel before signing this addendum. That's always a nice thing, even though we don't say it probably enough and buyers and sellers don't take advantage of it because they don't want to have that bill. This puts them on notice that, they really should learn what Ohio Revised Code landlord tenant laws are, and that maybe their attorney might scrap this and write something else. They might write up a lease. And as long as the buyer and seller are willing to sign it, we should have nothing to do with it and allow it to happen. So any questions about this? This is really just the minimum protection that you should be giving your buyers and sellers. Yes.
So I'm actually in a current situation like this where my seller places under contract and they're looking to buy it right now. The buyers have agreed to let them stay and have possession. So I already, in the beginning, I negotiated 30 extra days after closing. But here they reached out to my sellers and said, hey, we will, their agent, and said, we will let you lease, and because we really have our lease until it's a renter. So their lease is good, I think, until January. So you can stay as long as you pay the rent. So this is the form that I would use.
No.
Just kidding.
Yep. Yeah, just kidding, right. So you will have nothing to do with their continued leasing agreement that they're going to have after closing. So if I understand, the situation correctly, is you negotiated 30 days possession automatically in the purchase agreement. Okay. At that time, you could have or should have used this form during the negotiation process of the original purchase agreement. Okay. The fact that you have a buyer who has reached out to the seller that says, hey, we'll allow you to stay in the home even longer, they are the ones that should be negotiating a lease between that seller and that landlord. We will have nothing to do with it outside of the original purchase agreement that you have in place. So once those 30 days expire, that's it. We've done our job. Okay. So again, this form is not very common in our marketplace. I don't know if it is in other parts of the country. I doubt Because again, we're about the only part of the world that for some reason allows somebody to live in their house rent-free for up to 30 days or 45 days. Everywhere else in the country that I'm aware of, that's it. You sign on the dotted line, get out of the house. It's no longer yours, right? So what you originally did was you negotiated an additional 30 days without this form. It's common practice in our marketplace for that to happen. The problem is we're seeing so many disputes between buyers and sellers, and we are the ones representing our buyers and sellers and getting them into these situations. They'll end up calling us and saying, well, if I would have known that whatever was going to happen was going to happen, I would have never allowed the seller to stay in this house that long, or whatever the case would be. So that's why I say this form is available for your use. It protects our buyers and sellers. You may have used it if you wanted to. You could still use it for the 30-day window that you have available if they're willing to sign it, but anything outside of what the purchase agreement says for possession, we're done. Did everybody get that?
So if, even if their agent contacts me with one of these, we're done.
The agent, right, if the agent contacts you to negotiate a lease agreement between parties, they are mistaken. They are not the landlord, they are not an attorney, and most likely they're not a property manager that's being paid by the landlord. But certainly, even if any of those are true, you are not. You are not an attorney negotiating on behalf of your seller client. You are not a property manager that is negotiating on behalf of your seller client. You're not an attorney, and you're not a party to the contract.
What I have a question is how it happened, it transpired, how they found out they had extra time. And I was like, yes, they sold the house, they have an extra, 30 days to find it, let's go. You can pick a house. I already showed them so many houses, I'm like, finally they have to make a decision. And then they had an the buyer had an inspection done, opened the property, the whole family, I guess, came with the inspector, and then she left and locked up, left the family there. The inspector left. Yep. And then when my clients get home, they have the buyers are in their backyard with their dog. And that happened. And then they actually didn't get upset.
Was the buyer's agent at the inspections?
I'm sorry?
Was the buyer's agent at the inspections?
She was there, I think, for the beginning, but then left.
Yeah, so that's wrong. Okay, we'll cover that too.
Yeah, I was like, that never should have happened. I shouldn't even have that knowledge, but thankfully they didn't get, super upset. They ended up all drinking and finding out they had lots more time supposedly. So, I don't know.
And allow that to happen between them. Has nothing to do with you or Keller Williams. We can't control that situation and we don't want to be a part of it.
That's what I thought. Okay. Thank you.
Scott.
I remember having to reach out to you. We had somebody who needed to have a lease agreement, because you're talking about we don't write lease agreements. I just wanted to bring up because there are some brokerages that have lease agreements that were drawn up by their lawyers that we may come across. And I shared it with you to make sure it was okay.
Yeah, so the lease agreements that are written by a brokerage attorney, they are not supposed to be used for us giving them to a client to negotiate a lease or to write a lease on one of their investment properties or anything. That's originally intended for the fact that if I, as a listing agent, am hired by the seller as a property manager or agent for the seller to rent a property, to get it rented for them. Maybe I'm not going to manage the property, okay? But I'm going to lease the property for them. I'm going to collect the first month security deposit and the rent, and I'm going to give it to the seller, and then I'm done. Like, I'm out of it, right? The problem is agents are engaging in the practice of law by using that form for things that they shouldn't be, which is giving it to a seller and or buyer client saying, here, use this form to negotiate your lease. Or the new buyer landlord is saying, hey, do you have something that you could help me with? Do you have a lease available? And as a buyer's agent, I go, oh yeah, our company has one. Let me go ahead and send it to you. You fill it out, then you send it back to me and say, send this on to the listing agent in order to get the seller to sign it. No, we don't do that. So, that's one of the things where I say, we pride ourselves here at KWLG to say, Keller Williams is amazing. You guys can negotiate your own commissions. We give you a lot of leeway on signage and different things like that. Our fees are low, but one of the things that we don't do is provide you with property management documents, and we're not going to. Unless we decide to have a property management division at some point, we're not going to do that because Property management is the #1 complaint at the Division of Real Estate. The absolute #1 complaint, and it's the best way to get a very bad reputation for your brokerage. I mean, we could probably name 5 sitting here, if you've been in the business or lived in Stark County and never rented. I could probably name 5 different brokerages that have a property management division, and you could go online and type in and you're gonna see nothing but bad things about them, because that's what people do. People don't always say the good, they always say the bad. And when you type in a property management company, unfortunately, tenants complain about foolish things that they shouldn't, that the company has no control over, but they end up online. So we are trying to make sure that our agents and our brokerage maintain a very good reputation with our clientele so that we're not providing services like that. So sometimes it can be frustrating because you might say, why are we not doing this? Other companies have these forms. We don't, because we are better. We're not going to work in that environment.
I did leasing for like 3 years, so I totally know it's wrong.
Oh, there you go. Yep. We're testifying today. So, yeah, great. All right, so any questions then about this seller's occupancy after title transfer?
I want to text you about this more. So I'll probably be getting a contract. We've got that 60 days out back in there. So I'm going to use it.
Yes, 60 days out, you should definitely use this. But again, you know, you could also just advise your seller client or buyer client, hey, you should have a lease in place and let them work between the two people. It's very difficult for us as real estate agents to say, hey, contact the seller or contact the buyer, and you work amongst yourselves on doing this lease. Now, unfortunately, in these cases, we don't want a part of it. Excuse me. So you have to give them the information. You just don't have a choice. It's like, if you're going to retain in the property, you become a tenant, the landlord has the right to have the contact information.
In this situation, I don't think there's going to be rent or anything like that for the 60 days.
And there doesn't have to be rent. Just because somebody pays rent or doesn't pay rent does not constitute what Ohio Revised Code says a tenant is. You know, when you hear that possession is 9/10 of the law, that's exactly what they mean. I mean, I don't care if you're a squatter in a house that you've never owned and never lived in, and you have mail being sent there or not. If you're in that house and retaining possession of it, the owner will have to evict you and go through the proper channels. They cannot just come in and change the locks on you. I mean, that's why, you know, you want to secure your properties as best you can, because somebody gets in there, Ohio Revised Code now comes into play. So I may have never paid rent. You see these scams, for example, and I'll get off on a tangent here real quick, but you see these scams where, like on what is that, Craigslist, where you'll see, you know, somebody will steal our pictures from a listing, they'll put it on there and they'll say it's for lease. The landlord says to this potential tenant that drives by and says, yes, I want to rent it. Oh, I'm in California or Florida or whatever. I took the keys with me. I'm so sorry. Break the back door lock or break the glass and go ahead and get it. I'll send you the money to replace it, or I'll have my handyman come over and do it. And they actually, I know everybody's looking at me with these weird faces. Believe it or not, this happens. This is so crazy.
Stop
But
making up stories.
I know, you would think, like, you just think how foolish are people, but they do. So you have somebody, because they're in a desperate situation, they either have to move or whatever the situation is, or they're just so excited about this property that should be $1,000 a month to $700 a month. They send their deposit, they send their rent, they break the lock on the back door, the sliding patio door, whatever it is, they get in, they move in. 3 days, 4 days go by, maybe a week goes by, a neighbor comes over and says, hey, you know, welcome to the neighborhood, whatever. I don't know who you are. I didn't know they were renting the house, anything. Who knows? They could say anything. The listing agent goes by and thinks it's vacant and it's not. The owner goes over just to check on the water or whatever, and all of a sudden there's somebody in it. Guess what? You're not getting them out of there until you take them to court and evict them.
Yeah, they do the scams too, where my mom, it was like right by my house, it was right across the street. They put it on Craigslist and they were like, they put your information trying to get money from you.
Right.
And they take all your money too.
It's crazy.
This
So-
is why people say don't put your house on the internet, like pictures of your house, like on Facebook and stuff like that, because of BS like this.
Well, I mean, there's a lot of reasons. I mean, they could go to the extreme without even having pictures or your house even advertised. I mean, right now there's all kinds of things that scammers are trying to do. But I say those things because, like I said, it's one of those where most sellers and buyers probably do not realize how much strength a tenant has in a property. And they also think that it constitutes paying rent in order to become a tenant. That's just not the case. So that's why I say, these forms bring up a lot of great information that you may not realize or may not think about, because we have a million things going through our minds that you bring up now to your buyers and sellers, and they are super appreciative because you put it in writing and they're aware of it. All right, so that's the seller occupancy after title transfer. So let's talk a little bit about, I'm going to go back to something that was said. This is not an addendum, but because we have a lot of people in the class, I want to make sure that I say this. As a licensee in the state of Ohio, real estate licensee, you cannot give a lockbox combination out to anyone that is unlicensed. Okay, nobody that's unlicensed. I don't care if they're in a contract to buy the house or not. You don't give it to your buyers. You don't give it to anybody. You don't give it to home inspectors. You don't give it to appraisers without the seller's permission. So if you're representing the buyer and a listing is vacant, the appraiser doesn't call you to gain access and you say, oh yeah, the lockbox combo is 1, 2, 3, 4. When are you going in? That's fine. No, you're going to refer that appraiser to the listing agent, who is then going to take care of getting into that property. When you're representing a buyer, you should be there for the home inspection the entire time. You should be the one opening the lockbox. You should not be giving that code out unless you have the seller's written permission. And how that would go is you don't contact the seller directly. You would say, hey, I can't be there as the buyer's agent. I'm going to be out of town on vacation this particular day and my buyer's having an inspection. I'm going to write an email to the listing agent that's going to say, do we have your seller's permission to give the lockbox information to the inspector? And note that the inspector and the client will be there by themselves. There will not be a licensed realtor in the home during that time period. Is this okay? If the agent writes back yes, they are an agent for the seller. You're hoping that they convey that to the seller. The seller gave permission. Either way, you got back a yes, you're going to be cleared because you said, do I have the seller's written permission? What you don't do is you don't go to a home inspection, open the door, and then leave. And you leave a client in the home. So you are responsible for everything that happens in that home from the time that you set up that showing, that inspection, whatever the case is, and you need to be there the entire time. And if you can't be there, you better have another licensee there. Okay. I don't care if you have to pay it. I mean, in my career, I've had to pay people, even in sticky situations, it's like, oh my gosh, I'm gonna have to pay you $100 to sit there for 3 hours. It's what you have to do. I mean, it's just what you have to do to follow the rules. If you have a seller, if you're on the listing side of it and you have a buyer setting up an inspection, then a buyer's agent, you should ask them, are they going to be there? I mean, I just had one this past week where, the agent was asking for permission to, go in during this time. And I said, I just want to make sure you're going to be there the entire time. Yes. She answered back, yes, she was, as the buyer's agent. But some agents, including our own agents, do not know or feel that they need to be present at an inspection. Listing agents are not often at a home inspection. The buyer's agent is. Okay, so I know that somebody said to me in Gina's training classes, she would say, I don't normally go to my home inspection. She was typically a listing agent, not a buyer's agent. And that's why she says that. So be very clear and concise when you're hearing somebody say something on what the answer is, as opposed to what you think it is. Always seek clarification. Okay.
I was talking to one of my inspectors, and he said in the last 3 months that I've done, there's been no agent there. Wow. Not from any company.
Right.
Like,
It's a problem.
Yeah. Really.
Yeah, you must be there. So I go off on that because you brought up that situation, and I want to be very clear. Do not give access to a property without an agent being there. Okay. All right. So let's talk a little bit about earnest money, because this is an addendum that you can use, and it's, I guess, an addendum, but also a form, if you will. We're going to start the process. So let's say you have I don't care if you're on the listing side or if you're on the buy side, but in this particular situation, we're going to say you're on the buy side, right? You've written a contract, it's been accepted, or you've written an offer, now you have a fully executed purchase agreement, and you need to collect the earnest money. And I say that. You might have some other brokers at different companies say, oh, well, the buyer said they mailed it and that was good enough for us. Well, I'm going to tell you as your broker, believe it or not, the division looks very heavily at the agent on whether or not the earnest money was collected and how it was collected, and did you do your job to collect it. Now, contracts are different and the law is very vague. It just says the earnest money should be collected in a timely fashion. timely fashion could mean a lot of things. It depends on where the person is in the world. Do they have a credit card? Do they have a check? Do they have access to the mail? Do they have a stamp? There's all kinds of things that can happen. So you need to be very clear with your buyers on when you expect the earnest money to be collected. And I don't care if you have to drive to their house at 10 o'clock at night and get it. If that's the only time it works, I don't care if they have to drop it off in our mailbox at 10 o'clock at night or midnight. You know, I'm not saying you have to go out of your way and miss your children's recitals or whatever to get your earnest money, but make sure that you're working it out to get it collected. And when you collect it, you are going to make a copy of it. This is a great form to have for your records. You don't have to use it, but it's a great form to have so that it shows that, one, you always do the same thing. In case you ever get audited by the Division of Real Estate that says, hey, I collect the earnest money and I actually make a copy of the earnest money. I attach it here and I keep it as part of my .lib file. Okay, so this is just a great way to keep yourself out of trouble and keep the purchase moving forward. So today, earnest money can be paid in the form of cashier's checks, personal checks, wire transfers, ACHs. There's lots of ways to pay it. There's really no excuse ever for a buyer not to turn in earnest money. If you are a week into a transaction and you have a buyer that keeps coming up with excuses on why earnest money is not being collected, you should be letting the listing agent know you've not collected it and you don't have it. Okay, that's your job and your responsibility to make sure the listing agent has a copy of it and that they know you've collected it. Because we're hoping that you've done your job as the buyer's agent, that we're just assuming you've got it. The other thing is, when you put earnest money on the purchase agreement, the lender is going to say to you, I need a copy of that check. And then they're going to verify that it cleared the buyer's bank account at some point during the transaction. I can't tell you how many times it's happened to where the agent never collects it. We get all the way to closing. The lender asks for a copy of it. And lo and behold, we don't even have it because the buyer never mailed it, didn't drop it off. They sent a picture of it to their agent. We never got it. The title company never got it, whatever the case is. And now the lender says, well, you got to take that off the purchase agreement. You got to do an addendum that removes the earnest money because I can't use it because by the time it clears, we're already going to be closed and we can't do that. So the earnest money addendum or form, very, very good for you to use. I highly encourage you to do it on all your transactions and make sure when you're on the list side, get a copy of that earnest money too, because you're just as responsible. If a deal goes south and a seller says to you, hey, I don't want to sign a mutual release, giving that earnest money back to the seller or the buyer, and you have to say to them, oh, well, funny thing, the buyer never sent it and I never verified that they didn't send it. Whoops. You're going to be very unhappy with you. Okay. So a cover earnest money, it's something you definitely want to do in your transaction if there's earnest money. Now, earnest money, some purchase agreements say it's turned in within 4 days, 4 business days. Some say that it's turned in after the removal of contingency. So you need to read it and understand when you're collecting the earnest money or when you're giving the earnest money. Okay. Any questions about earnest money?
Just, is there anything when you're on the listing side and that buyer side doesn't get their earnest money turned in, like what can you do?
Well, they're in breach of contract. I mean, it says that, so like our purchase agreement says that it's due upon acceptance. Well, when you fully execute the purchase agreement, if you haven't given the earnest money and you don't give it within a couple days, you're in breach of the contract. So unfortunately, you know, if I were the seller, I'd say, well, I'm sorry, but you're not doing inspections on my property until you do that. And I understand I signed a purchase agreement that said you have 7 days to do it, and I agreed to that, but you breached the contract. So I'm not moving forward until you get this corrected. And here's the, now I'll go into that some other time. There's a lot of things legally that you can go into with all that, but let me see what the chat is. Linda Sigler, happened on a listing of mine in Alliance a few years ago. Okay, sorry, Linda, we catching up on those, but so that was probably from one of our previous stories. All right, so any questions regarding earnest money? All right, perfect. All right, so we have we've collected our earnest money, we are doing our inspections, and the next step is, if we are representing a buyer, we are removing contingencies, okay? Our purchase agreement and most purchase agreements throughout our county require a removal of contingency. Cutler does not. If you're dealing with a Cutler real estate agent, their purchase agreement does not have release of contingencies. It's Jay Cutler's position that you never release a contingency. They automatically get released at the time of closing, okay? So when you work with a Cutler agent, if you're on the list side, you're not going to get that ROC that says, I want the seller to do this, this, and this, and releasing the contingency. You're going to get an addendum that asks the seller to make repairs. That's the only thing you're going to get, okay? Now, when you write a purchase agreement, Keller Williams on a Cutler listing, you're following our purchase agreement, which says you're getting a release of contingency. Okay. The only time you're not is when it's a Cutler purchase agreement on your listing. Okay. So there are a few of these available. I'm not going to go over all of them, but I'm going to show you the few that are different, and I'll show you a few of the differences. So this is the most widely used one. This is in our forms under dot loop under the buyer forms, as well as miscellaneous, and it's also in the interactive documents with the MLS. Okay. This form covers different financing, closing, possession, contingencies, and things like that. But it also covers the inspection contingencies. So 3 days from the date of the last completed inspection, so you've got the results back from the last inspection, right? You need to provide this release of contingency to the listing agent and get the sellers and buyer signatures on it within 5 days of providing it to that listing agent. If you don't, you've got a problem with our contract. You're not following the contract. Okay. So our purchase agreement says that you're going to perform inspections within X amount of days, and within that time frame, 3 days after the last completed one, you're going to provide this form, and then 5 days after that, or within that 5 days, it's going to be fully executed. If those 3 things don't happen, you have a problem. That means you're not following the contract, and after those 5 days, the purchase agreement can be null and void by either party. Right, Scott?
So it's within 3 days of the last inspection, not getting the results.
Well, it's getting the results. A completed inspection. So completed is
The results are there.
could mean different things to different people. Completed means I was at the house and I did the inspection and I'm done. Completed to us, and again, this is a legal thing. So, you know, the attorney writes this contract, but completed to our contract, the understanding is completed means I didn't just do it, I have the results of it. Like I know that it's complete, like I know what's going on. Some agents will argue with that, but it's kind of hard. So you completed an inspection, you claim, but you don't have the results of it. How's it complete? It's not. So it's like saying that I wrote the check for the earnest money, but I didn't turn it in. I didn't complete it. Right? So this form, again, widely used by a lot of different real estate companies because it is in the MLS. But this would say that you're removing you're removing contingencies, or you're removing them subject to asking the seller to make repairs to these. Now, there may be times where, let's say, for example, you provide this document to a seller and a seller says to you, I'm not signing anything because I need to get estimates on roof or hot water tank or furnace or anything like that. That's fine. You still have to follow the contract, which means if you're not using this form in the time frame that it's supposed to be, then you need to come up with an addendum, a blank addendum, and you're going to extend the inspection period. So if your inspection period was originally 7 days and you're on day 9 now because you've completed all the inspections and this form is next, and you have a seller that says, nope, I'm not doing that, then you're going to redirect, you're going to get a blank addendum, and you're going to say, you know, buyer and seller agree to extend the inspection period to, you know, 10/20 or whatever the date would be, the future date. That keeps your contract in contract, or keeps you in contract rather, and keeps the time frame to where now, after getting that next answer on whatever the inspection and price is on a new roof, now you can move forward with the ROC. So make sure you're always staying in contract one way or another. Now, the ROC might say something like, you could do the ROC and it could say seller to get estimates and replace roof. I mean, you could write it however you want to, whatever is comfortable for you and the buyer and the seller to agree on. But in some instances, sellers say, I'm not signing anything until I have the answers. So you could do the addendum, or you could say, you know, seller to replace up to a cost of $10,000 for a new roof. There's a way to make it work. You can make it work. It just may not. Every form, again, doesn't fit every situation. Okay? But you'll always have an ROC with our purchase agreement. So any questions about when an ROC is due or how you use it?
I have a question.
Yes.
So I'm doing one right now, and I just use an addendum that said reduce purchase price by 2,500. Do I still need to do this?
So that is not an ROC. Yes.
Yeah.
An ROC is specifically a release of contingency,
Okay, so-
which is a specific form. So you would want to use this form. So you would say, maybe, so was it due to the general home inspection? There were issues. So you're going to say, remove subject to conditions listed below. Seller, then you'll edit the text here. Seller and buyer, or seller agrees to reduce the purchase price to blank in lieu of repairs, or whatever the case would be.
So even though I already did that on an addendum, I'm doing it again here.
Well, unfortunately, I mean, this is a learning, and thank you for coming. So that's one of the things that, yes, an addendum does not change the fact that you needed the ROC.
Okay.
So the addendum is just saying that you've changed the price. It didn't release the inspections. So unfortunately, a buyer or seller could, should they wanted to invoke the fact that you don't have a fully executed ROC within those 5 days of being presented with one in the 3 days, they could null and void the contract. So it could harm your buyer or seller depending upon who you represent. And you know, here's the thing, a lot of people think, oh, well, the buyer has the control. Not in this market, they don't, the seller does. And so a seller could absolutely, you could provide them with this and the seller could say, I'm not making any repairs. 0. So you either change that to reflect 0, or I'm not signing anything. And you as the buyer's agent, and the buyer, if you're not paying attention to the contract, 3 days go by, 5 days go by, you're hoping to still work it out. You're hoping you're going to come up with something. And the seller says, I invoke this paragraph on your purchase agreement and I'm null and voiding the contract. You didn't do what you were supposed to, so we're out. Guess who that buyer is going to be real angry with? You. So that's the situation why you need an ROC, even though you have the addendum.
Okay, yeah, Gina just told me to do the addendum, so I did the addendum, but.
And that's why we go over the addendum. She probably, when she said addendum, she was most likely meaning the ROC,
Okay.
but the word is, I suppose, interchangeable. The other thing is too, is the ROC, when you're doing something like you're talking about, the release of contingency is not calling attention to the fact that you're reducing the price of the house for repairs to the lender like an addendum is. See, every addendum that we write, you're supposed to provide that addendum to the lender. They're supposed to have a copy of every single thing that's an addendum in the purchase agreement, including the purchase agreement. So when you do what the way that you did it, if you send that to the lender, the underwriter might pull up a red flag and say, whoa, what repairs need done? We may not be moving forward or closing on this until these repairs are done. If it's maybe septic or well or lead paint, or who knows what it could be. I don't, whatever the situation is. So unfortunately, that can call attention to it. And we're not doing our job by not providing the addendum to the lender. Now, I will tell you, most agents don't, or most lenders, the loan officer says, I don't want to see it. So, we have to continue to make our real estate transactions go through. And sometimes you have to, not give information. It's not lying. It's just not submitting all the information. So in your case, I would highly suggest doing the ROC. And then that way that, first of all, follows the contract. 2, you're not giving that to the lender. Does that make sense?
Wait, I'm not giving this to the lender?
Well, the ROC is not going to be given to the lender because it's release of contingency. You're saying that in lieu of repairs. And what I'm saying is if you use that wording on there, the lender may say to you, we need to know what the repairs are. We need to know. So what I'm saying is in your particular situation, the way I would do it is I would use the ROC and say subject to conditions listed below. And in this edit spot, I would say something like see addendum A. And I would leave that, and then I would get the blank addendum that you probably had, and I would label it addendum A, and I would have the seller sign the ROC and the addendum. But on that addendum, I would not use the words prices reduced due to home inspection issues. I would say something like buyer and seller agree to reduce price to X. You don't need to say Y, because that particular addendum should go to the lender. The ROC would not.
Okay, yeah, I already did all that, sent it to the lender.
Okay,
And I
well,
just put, we're reducing the price.
then you should be okay.
Okay.
Yeah, and not all lenders will do that. I'm just saying, unfortunately, that can cause a problem that you don't intend to cause. That's all.
So if you checked, remove subject to, you've got all this stuff. Once all this stuff is done, what's the best practice to clean this form up?
Well, there's no cleaning it up.
I mean, once it's done, and then you remove, now they've done it, they've done the work, and now you just say, okay, now we're done, now we're removing it. So
Well, you're not removing it though. That's the whole thing is you're removing it here as long as the seller agrees to make those repairs. Now, if you get to closing and the seller hasn't made the repairs, then unfortunately The only thing you've done is remove the inspection contingency part of it. You're like, I'm moving forward. We did our inspection. I'm good if you do this, and we're all on the same page. But if you get to closing and the seller hasn't made the repairs, then you have one of two choices. You either close on the house or you don't. And I'm going to tell you that based on all the experience that we've had with this, the buyer still better close on the house, even if the seller didn't do those things. And then they can turn around and take the seller to court for not doing them, and they have the forms to do it. But if the seller doesn't close, I'm sorry, if the buyer just simply says, I'm not closing on the house, guess what? They're actually the first ones to breach the contract, not the seller. Even though the seller didn't do the repairs, the buyer didn't close on the house. You had it's really backwards. You would think that it would be the other case, but it's not. And so attorneys will say, close on the house and then make the repairs and then sue the seller for them. But before you would get to that point, our contract states that you would, during the walkthrough, you would do an addendum that puts the seller on notice of what either wasn't done or damage to the property that occurred between the time that they wrote the offer and now. You would hopefully negotiate that and work it out. But if it doesn't, most likely the attorney that they would call would say, you still need to close on the house. I understand the dog urinated all over the living room carpet and you don't want to buy the house anymore. But if they hadn't done that, you intended to buy the house. Is that correct? Yes, I did. Then I tell you to close on the house so you don't breach the contract. Have the work performed to replace the carpet and clean it, clean the underlaying floor or whatever, replacing it, whatever the contractor says. Then come back to me and we will sue the seller for damaging the property. I know it stinks and nobody likes these answers, but that's the answer.
So on every purchase agreement that we write, unless we say, hey, we're completely removing any inspections on the home, you're gonna need this.
Yes. You absolutely need an ROC on every single purchase agreement that Keller Williams writes, because it's in our purchase agreement specifically that you will do this document.
Okay. Got it.
Even if there's not, if there's no.
Well, if there's no contingency, then no. If you have no inspections, you've removed them all right then.
Okay, so no matter what, you are putting contingencies on the home as soon as you mark.
Right. I mean, most of the time, you got to think. So our purchase agreement has a contingency for financing in it. You have inspection contingencies. There are title issues, if title issues arrive. So you've got to have clear and clean title. So there's a lot of contingencies that protect the buyer in here. This is just another one.
Okay. Yep.
All right. So we're a little over an hour into this. I'll kind of try and wrap up a little bit so you guys aren't here all day, because I think we had till about 1 o'clock. The blank addendum that you most likely used was this. Does that look like what you used?
Yeah.
Okay. And these addendums, this blank addendum is available for you to use. It really is. You just have to be careful what you're putting in there. What you understand and what a seller or a buyer understands are totally different. And again, you're not an attorney. You can't practice law. I mean, I've seen these come across where you think that somebody thinks they're an attorney, and you're just like, wow. Where they thought they covered everything and they missed something that you see so blatantly that they thought they covered everything on. And unfortunately now it's got them in trouble. And for our internally, you're not going to get in trouble. But if this were to go to an attorney, they would absolutely, most likely your real estate license could be revoked or suspended, but you could get in trouble for practicing law without a lawyer. So, I mean, it's the same thing. If you are if you're not a real estate agent, and you list a home for sale or represent a buyer or seller on a home sale, the state of Ohio can actually come after you for practicing real estate without a real estate license. We are no different than an attorney. A license is what you have to practice real estate or law, and they should not cross. Okay. All right, let's see, a couple addendums. Well, you know what? Let's talk about the mutual release. We'll end on this. A mutual release, I just want to clarify that there are only 4 ways that earnest money ever gets distributed. You can call me, you can cry, you can complain. Your buyers can call, the sellers can call. You can give me every story you could possibly ever imagine. I don't care, and neither will anybody else. There are only 4 ways earnest money is distributed. That's the way the law is. In my opinion, the earnest money laws are archaic and they need to be revised and changed. But for right now, this is the way they are. The first one that you're going to, the first way to have earnest money released is a successful closing. We love those. Everybody's happy, close on the house. The title company sends the earnest money to us, or we send it to them, whichever way it happens. We're good. Great. The second way is a fully executed mutual release. And this tells whoever is holding the earnest money who to give it back to. Is the seller getting it? The buyer getting it? Is the broker getting it? We'd love for the broker to get it. That doesn't happen often. But nonetheless, this tells who's going to get it. It has to be fully executed by both parties, the buyer and the seller. So if you have a husband and wife and only the husband signs it, that's not fully executed. You've got to have both owners or all owners of the property and the buyers that were on the purchase agreement signing this form. Okay. If that happens, we will give the earnest money back, or the title company will give the earnest money back. So that's way number two. If the first two don't happen, the third way is the buyer or seller, either party can take the other one to court. And with a court order, we can release the earnest money. That has to come from the court directly, and the title company can, whoever's holding it can release it. The fourth way is after 2 years, if neither three of those have happened, then after 2 years, we as a brokerage can write a check to the party that wrote the check, not to the seller, not to the buyer. It has to go to the party that wrote the check. So if grandma and grandpa wrote the check, that's who we're giving the earnest money back to. Okay. And if we cannot locate grandma and grandpa, we must send the funds to the state of Ohio as unclaimed funds in that person's name. If it ever gets claimed, great. If it doesn't, it doesn't. We've done our duty. That's it. You're not getting earnest money back for any other reason at all. Any questions about earnest? Okay, so the best way to do it is always try and get the mutual release signed. Now, I'm going to give you some tidbits on the listing side of it. If your seller says, I'm not signing the mutual release, but I want to put my house back on the market because the buyer's financing fell through, whatever happened, whatever, that's fine. You can put the property back on the market once you've received the mutual release. The other agency is going to be very upset with you, and they're probably going to call me, or because you're not getting this signed. The seller says, I don't want to sign it. And without a fully executed mutual release, the MLS is going to tell you, you need to put it back under contract, or the closing date has to come and go. If the closing date has come and gone, the buyer hasn't performed, you can put the house back on the market. But let's say we're 15 days into it. We do inspections. The seller says, no, I don't agree with these findings. The buyer says, well, too bad, I want out of the deal. The seller says, well, out of spite, I'm not signing it. But the buyer's agent sends us over a mutual release. They've now given us the intent that they want out of the transaction. The seller can put the house back on the market. As a broker, I will have to send a letter to the MLS holding them harmless from any liability of being sued because they're misrepresenting the advertising of the property as active when in fact we have a legally binding contract that says it's under contract. You can still accept a contract on it, but mind you, if the seller gets sued, obviously everything stops. That ties up that property. So we're taking a risk whenever we're not getting a mutual release signed. You always, always, always want to try and get a mutual release signed. You should convey to your seller, it is in their best interest to get a mutual release signed if the buyer doesn't want to move forward. Unless there is a particular reason that they don't want to, then they should seek legal counsel. Don't force them to sign something. Tell them to seek legal counsel. But if they don't want to sign it, they're not going to sign it. Okay. Same thing with you. If you're on the buy side, your buyer doesn't want to move forward, you send over the mutual release and the seller says, I'm not signing it. Most likely, your buyer's not going to get their earnest money back for 2 years. I have seen where the house goes back under contract again. And sometimes when you reapproach that listing agent, the seller all of a sudden says, yep, I closed on the property or we got another contract, fine, I'll sign the mutual release and get the buyer their earnest money back. Like I've moved on from it, I put enough energy into it, I'm ready to move forward. And that's great too, get them to sign. But those are the only way the earnest money is getting distributed, okay? Any questions? Okay, I'll get you guys out of here a couple minutes early. Does anybody on Zoom have any questions? Becky, you like came forward like you have a question. But you're not saying
I do. I have a quick, I hope, question.
Let me
So when
turn
you
on-
said that
It's
with
not
the
turning this on.
contingency, the ROC, with the ROC, it has to be done completed within 5 days. I know
Okay,
that-
sorry, we just got your voice. You'll have to start over. I'm sorry.
Okay, sorry. You can hear me now?
Yep.
Okay, so you were talking about the ROC. Now, I sent it within like I sent it at 3 days over to the sellers. So they have to get it back to me basically today, because that would be 2 more days. So 5 days total that it has to be complete.
5 days after receipt. So you have 3 days to provide it to them. From the time that they receive it, the listing agent gets it. There are 5 days. So if you're on the listing side, you received it 2 days ago, you still have 3 additional days. If that's
Awesome. Okay, thank you.
Any other questions? Okay, guys, hopefully it's been helpful. Have a good day. Thanks. Yes, it is recorded. Yes, so access